Studies paper 3. See, this particular topic which we have chosen for discussion today, it can come even in internal security or it can come in science and technology. So this is regarding the data protection bill, which is very much in the news since now the 2019 draft bill has been put in public domain. Before we start the discussion on this particular topic, we see the question. The current Indian privacy law is inadequate and improperly enforced. In the light of this statement, examine whether the Data Protection Bill of 2019 is an improvement. So what we are going to analyze in this particular question is whether the current Indian privacy law, the question says the current Indian privacy law is inadequate and improperly enforced. So first, a background regarding the data protection. See the background. In 2017, the Supreme Court in Puttaswamy versus Union of India. Puttaswamy was a retired judge of the Supreme Court. He had contested the provisions of the Aadhaar Act, saying that it violates privacy. Now, when the Supreme Court, after hearing the judgments in the arguments in the particular case, Puttaswamy versus Government of India, came to the conclusion that right to privacy is an integral part of Article 21. So Article 21, right to life and liberty, means right to privacy. And it also said that right to privacy is an integral part of integral part of Part 3 of the Constitution. See, Part 3 deals with fundamental rights. So it said privacy, apart from being an implied right under Article 21, is also covered in Part 3 of the Constitution, that is fundamental rights. Article 14, 19 and 21. The Supreme Court also said that the right to privacy is not absolute. Like other fundamental rights, it's subject to reasonable restrictions. This happened in 2017. 2018, government appointed the B.N. Sri Krishna Committee to go into the privacy law. This is just after the judgment in the Puttaswamy case. The B.N. Sri Krishna Committee made certain recommendations. The first thing it said was individual consent. Suppose my data has to be taken, facts have to be taken, individual consent is required. Then it also spoke of the right to be forgotten. What do I mean by right to be forgotten? It means the right to correct whatever data has been given earlier. It proposed a data protection authority. It proposed a grievance mechanism. Now, one thing in this B.N. Sri Krishna Committee report, what it said was personal data can be processed without the individual consent. Just see this. Personal data can be processed without the individual consent for exercise of the state's functions. So the B.N. Sri Krishna Committee, this particular recommendation of the committee goes contrary to the Puttaswamy case. Since there were many glaring loopholes in the Sri Krishna Committee report, government thought of making having a relook at the B.N. Sri Krishna Committee, and now the 2019 it has come about with a draft data protection bill. So this is the background for the Data Protection Act, Data Protection Bill. Then we go to the provisions of the bill. See the provisions of the bill. First, it says all internet companies to store critical data of individuals within the country. So the companies can store critical data of individuals within the country, and suppose the company wants to transfer it overseas, they have to take the consent of the owner. Another important feature of this data protection bill is there is something called sensitive data. What is sensitive data? Sensitive data is that which is defined by government relating to health, religious, genetic, and financial issues. So sensitive data is one which can be defined by government. Then regarding the powers of the social media to come up with a mechanism to identify users who are willing to be identified on a voluntary basis. Then one important feature of the bill, it is again copied from the Sri Krishna committee report, right to connect, right to erase, posting of data. This is the right to be forgotten. So this feature is taken directly from the BN Sri and Sri Krishna committee report. Then the important feature of the bill, it says data can be processed for lawful purpose. There cannot be any misuse of data. It is only for lawful purpose. Penalties. The draft bill proposes a penalty of 15 crores or 4% of the global revenue if the entity violates the provisions of the bill. Minor penalty of 5 crore or 2% of the global turnover. These are the penalties proposed in the draft bill. Now, in the features of the bill, we said individual consent is required before data can be sent overseas. Now, there is an express provision which states that explicit consent is not required in several cases. The draft bill says security of the state. So matters affecting the security of the state, the provisions of the bill will not apply. The security of the state is security of the state. The state will define what is security and what constitutes a threat to security. Relief in medical emergencies. Here also, explicit consent is not required if data has to be shared. Determination of unlawful activities. Now, if the government comes to know that a lot of unlawful activities are going on, it can check, it can prevent misuse of data, prevent data sharing. Whistleblowing. So whistleblowing is also a feature where explicit consent is not required. Then, see, government can direct the data fiduciary to share anonymously data for better targeting of services. So government has got an overriding power of directing the agency to share anonymously data for better targeting of services. So these are the areas where explicit consent is not required. Then when we spoke of the data protection bill, we come to certain issues of concern. See, the scale of data collection is broadly contained in Digital India. Now the government has got the scheme of digitalization of services. We've got an ambitious program of Digital India. So here collection of data is enormous. Then elements of a citizen-state interaction are data fed. So citizen-state interaction. So a lot of data being stored by the state. So it could be a threat to an individual's privacy. The second issue of concern, in thinking about data as a public good. See, the Economic Survey Volume 2 makes an observation. In thinking about data as a public good, care must be taken not to impose the elite preference of privacy. So the Economic Survey says, don't think too much of privacy. The privacy thing is only the concern of the elite, not the poor, who want a better quality of life. They are willing to share the data. They know government cares for them. It is the elite who are raising the bogey of privacy. The third issue of concern will be, now you are placing the privacy interest of the individual on the same footing as those of the business and the state. So the privacy concerns of the individual and the concerns of the state, they're all placed on the same pedestal. So as I said earlier in the discussion, the draft bill is still under it's on the public domain. They've called for objections. So this is an event which is currently in the news, an issue which is currently in the news and is related to the dynamic aspect of general studies. So general studies paper 3, it could come in internal security or it could come in science and technology. So we started a discussion on the data protection bill by observing that first how the Supreme Court brought up the issue of right to privacy in Putswami versus Union of India in 2017 by holding that right to privacy is a part of 14, 19 and 21. It's an implied right. However, it said the state can impose restrictions. Then we had the B.N. Sri Krishna committee report which made certain recommendations. Since these recommendations they had a lot of loopholes, or the government wanted to further streamline the issue of privacy in the light of the Supreme Court judgment in 2017. So it brought about the draft Data Protection Bill of 2019. Then we spoke of the provisions of the bill. We said how internet companies can store critical data within the country, and if they have to share it outside, they require the consent of the individual. Then we also said what is sensitive data. The government can decide, especially if it is issues relating to health, finance, religion, and genetic. Then a feature of the Sri Krishna report coming again in the draft bill, right to be forgotten, that is the right to erase, connect, posting of data, altering the data. Then we also spoke of the penalties, the major penalties, the minor penalties proposed in the bill. And we spoke of where individual consent is not required at all. That is the interest of the state. If whistleblowing is there, then unlawful activities. Then government can direct the fiduciary to share the data for better targeting of services. Finally, we concluded our answer by speaking of certain issues of concern, like how the individual and the state are kept on the same pedestal. One side we speak of the right to privacy, other side we are speaking of the interest of the state. Then another feature we spoke of is whether taking or storing so much of data in the name of digital India, whether it is not whether it is a threat to right to privacy. And how the economic survey, which mirrors the views of the government in volume 2, it clearly says the question of privacy is just a bogey expressed by the elites, and the majority of the poor who are satisfied with the services provided by the government are more interested in a better quality of life than the talk of privacy. So this is an answer for the question which we have taken up for discussion in General Studies paper 3.